In the early 1600s, Dutch merchant ships set sail for the Indies carrying cargo worth millions in today's money. But those ships had certain legal powers that many actual human beings lacked. They could enter contracts, get dragged into court, and when they inevitably sank or got captured by pirates, their specific debts stayed contained while their investors' personal wealth remained safely out of reach. The ship itself was a distinct legal person. This wasn't an obscure technicality. This was a crucial foundation that shaped how corporations work today. Hi guys, I'm Monty and I'm a linguist and a history enthusiast. I create videos that give you a new perspective on modern concepts. If you learned something from this video, please consider liking it and subscribing to my channel to help me grow and create more of this kind of content. And let me know in the comments what you'd like to see me talk about in my next video. We live in a world where corporations have become so powerful they rival nation states, where Apple sits on more cash than most countries' entire GDP, where the legal fiction of corporate personhood lets entities claim religious freedom and free speech rights. We've been told this is modern innovation, that the corporation emerged during the industrial age as this brilliant solution to large-scale business problems. That story? It's missing half the plot. The real story starts not in smoky boardrooms or industrial factories, but on the rolling decks of medieval merchant ships. For centuries before anyone chartered the first modern corporation, maritime law had already cracked most of the major problems that corporate law later claimed to solve. Ships functioned as distinct legal entities. Ship ownership got carved up into shares that you could buy and sell. Investors enjoyed protection from personal liability. Management was centralized under captains with sweeping authority. And when disasters struck, which they did constantly, the ship's assets were often shielded from the personal debts of whoever owned it. What we're looking at isn't just the history of business organization, it's the history of a legal innovation so successful that we've completely forgotten its maritime roots. Understanding this forgotten origin story reveals something unsettling about our modern corporate predicament. We're not living in the age of the corporation, we're living in the age of the ship. To understand how ships became early versions of legal entities, we need to travel back to a time when the very idea of limited liability was considered morally outrageous. In medieval Europe, debt was personal, brutally personal. If you borrowed money and couldn't pay it back, your creditors could seize not just your property, but your actual body. Debtors' prisons weren't metaphors, they were real stone buildings where you rotted until someone paid your debts. Bankruptcy meant social death. But the sea changed everything. Maritime trade demanded massive capital investments with absolutely staggering risks. A single storm could obliterate months of accumulated wealth. Pirates could seize entire cargoes, frequently and systematically. Foreign ports might confiscate ships on political whims or for diplomatic leverage. Under traditional partnership law, these disasters wouldn't just bankrupt the immediate investors, they'd bankrupt their families for generations. So maritime law evolved a radical solution. The ship became a legal entity completely separate from its human owners. This wasn't metaphorical. In admiralty courts, lawsuits were literally filed against the ship itself. The ship Mary, her tackle, apparel, and furniture. The ship was treated as the defendant, with its own legal standing and its own assets and liabilities that courts could pursue. This legal treatment served a crucial economic function. When the ship Mary got sued for unpaid debts, only the ship's assets were at risk. The investors who owned shares in the vessel, and yes, ship ownership was divided into shares, often 60/4, centuries before stock exchanges existed, could lose their investment, but their homes and other property remained largely protected. The ship's debts were confined to the ship. Consider the implications. In 1347, when the Black Death reached European ports, the legal and economic disruption was enormous. Ships arrived carrying not just goods, but devastating plague. While the human and social costs were catastrophic, the legal response often focused on the vessels and their cargoes, rather than pursuing ship owners' personal assets indefinitely. This helped contain some of the financial chaos during an already devastating period. This wasn't just convenient legal fiction, it was revolutionary economic engineering. By creating artificial persons in the form of ships, maritime law had solved the fundamental problem of large-scale investment. How do you pool capital for risky ventures without exposing investors to unlimited liability? The ship became an early form of a limited liability company, centuries before such companies became widespread on land. But legal personality was just the beginning. Maritime law also pioneered what we now call entity shielding, the principle that the entity's assets are protected from the personal debts of its owners. If a ship owner went bankrupt on land, his creditors couldn't just seize his shares in the vessel. The ship's assets belonged to the ship, not to its human investors. And like modern corporations, these sea-based entities had centralized management under professional executives, the ship's captain and officers, who were granted broad authority to act on behalf of the entity. A captain could enter contracts, hire crew, purchase supplies, and make strategic decisions without consulting the ship's owners, just as modern corporate executives operate with delegated authority from shareholders. The story gets complicated when we examine the legal machinery that made ships into artificial persons. It was built on a foundation that we've completely forgotten, the maritime lien. A maritime lien is a claim against a ship that travels with the vessel regardless of who owns it. If a ship's crew goes unpaid, they don't just have a claim against the ship owner, they have a claim against the ship itself. If the ship gets sold, the lien follows it to the new owner. The ship, as a legal person, remains responsible for its debts even when its ownership changes hands. This created something unprecedented in legal history, a form of property that was also a person with its own rights and obligations that existed independently of its human owners. The ship could be arrested, tried, and condemned by courts. It could be held in jail, dry dock, while awaiting trial. It could even be executed through judicial sale. But the maritime lien system did something else that we've completely lost in modern corporate law. It made the artificial person accountable for harm it caused. When a ship collided with another vessel, when cargo was damaged, when crew members were injured, the ship itself was liable. And unlike modern corporations, which can simply dissolve and reform to escape liability, ships couldn't disappear. They were physical objects that could be seized and held accountable. This accountability gap explains our modern corporate crisis. We've inherited the legal machinery of maritime law, the artificial personhood, the limited liability, the entity shielding, but we've lost the accountability mechanisms that made it work. Modern corporations can claim the rights of persons while avoiding the responsibilities that maritime law imposed on its artificial entities. The transformation began in the 17th century, when European trading companies started adopting maritime law principles for land-based ventures. The Dutch East India Company, chartered in 1602, was essentially a ship-based entity that happened to own multiple vessels. It had legal personality, limited liability, transferable shares, and centralized management, all borrowed directly from maritime law. But there was a crucial difference. The Dutch East India Company wasn't subject to maritime liens. It couldn't be arrested and held accountable in the same way a ship could. It was an artificial person with rights but fewer obligations, a legal entity that could accumulate power without the traditional constraints that maritime law had developed over centuries. The English East India Company followed a similar model, and by the 18th century, this hybrid form, maritime law principles applied to land-based entities, had become the template for what we now call the modern corporation. But something essential was lost in translation, the physical accountability that made maritime artificial persons workable. Ships were artificial persons, but they were artificial persons you could arrest. Corporations became artificial persons you couldn't touch. This isn't just legal history, it's the origin story of our current predicament. We live in a world where corporations claim free speech rights, religious freedom, and political participation rights as artificial persons, while simultaneously claiming immunity from the kinds of physical accountability that maritime law imposed on its artificial entities. We've created artificial persons with all the rights of humans but none of the vulnerabilities. The deeper you dig into this history, the more you realize that our modern corporate crisis isn't an accident. It's the predictable result of adopting maritime law's solutions while abandoning maritime law's constraints. Consider what happened to the concept of limited liability. In maritime law, limited liability served a specific economic function. It allowed investors to pool capital for extremely risky ventures where total loss was a real possibility. The limitation wasn't arbitrary, it was tied to the physical reality of the ship and its cargo. You could lose everything invested in the vessel, but no more, because there literally was no more to lose. Modern corporate limited liability has become something entirely different, a tool for externalizing costs onto society while privatizing profits. Corporations can engage in activities that cause massive environmental damage, public health crises, or financial instability, then simply declare bankruptcy and walk away, leaving the cleanup costs to taxpayers. The physical constraint that made maritime limited liability economically rational, the ship itself, no longer exists. The same pattern appears with corporate personhood. Ships were legal persons because they needed to enter contracts, own property, and be held accountable for their actions across multiple jurisdictions and legal systems. The personhood was functional, tied to specific economic needs and balanced by specific legal obligations. Corporate personhood has evolved into something far more expansive and far less accountable. Corporations claim constitutional rights to free speech, allowing them to spend unlimited amounts on political campaigns. They claim religious freedom rights, allowing them to impose their owners' beliefs on employees. They claim due process rights that make them nearly impossible to regulate effectively. But they can't be imprisoned, they can't be executed, and they can dissolve and reform at will to escape accountability. What we're witnessing isn't the natural evolution of business organization. It's the result of taking maritime law's solutions out of their original context and applying them to entities that don't face maritime law's constraints. Maritime law offers time-tested solutions to the problems that plague modern corporate governance. The maritime lien system shows how to make artificial persons accountable for harm they cause. The principle of general average, where all parties share in losses caused by decisions made for the common good, offers a model for corporate responsibility that goes beyond shareholder primacy. Some jurisdictions are already experimenting with these ideas. Benefit corporations, which are legally required to consider stakeholders beyond shareholders, echo maritime law's broader conception of entity obligations. Proposals for corporate criminal liability that would treat corporations more like the accountable artificial persons of maritime law are gaining traction in legal scholarship. The question isn't whether we can create more accountable forms of artificial personhood. Maritime law proved that centuries ago. The question is whether we're willing to abandon the convenient fiction that corporations are just private property arrangements and acknowledge them for what they really are: artificial persons with real power and real obligations to the societies that create and sustain them. We're not going to uninvent the corporation any more than we could uninvent the ship, but we can learn from the legal tradition that created both, and remember that artificial persons were originally designed not just to accumulate capital, but to be held accountable for how they used it. 600 years after those first Dutch merchant ships sailed with distinct legal identities, we're still living with the consequences of that legal innovation. Every time you interact with a corporation, buying products, working for wages, voting in elections influenced by corporate spending, you're engaging with the descendant of those medieval ships that were granted artificial life by maritime law. The corporate crisis we're experiencing isn't a bug in the system, it's a feature. We've created artificial persons with immense power and minimal accountability, and we act surprised when they behave like sociopaths. But the solution isn't to destroy artificial personhood. It's to remember that personhood, even artificial personhood, was always supposed to come with responsibilities as well as rights. The ships knew this. Perhaps it's time we remember.